Does South Carolina have an ADR program?
Yes, we do.
And how does that work?
Well, ADR is an acronym for Alternative Dispute Resolution. And in South Carolina, generally, every case that is litigated in our circuit courts, our civil courts, have to be mediated. And so that is one aspect of our ADR rules. And I think it's a great rule that we have because many parties wouldn't mediate if they weren't required to mediate. Mediating is essentially a form of settlement negotiations in which you have a mediator who is a neutral party, disinterested in the outcome, that helps the parties arrive at a voluntary settlement. It is not coercive and it is not binding. Oftentimes mediations will lead to a settlement, but sometimes they don't, and the parties will then continue on to a trial. The other aspect of the ADR rules is arbitration. That's a whole other can of worms. Arbitration is sort of like it's sort of like a court case in which you're paying an arbitrator to be the judge. And generally, those decisions by that arbitrator are binding on the parties. So it's not voluntary, it's more coerced, for lack of a better term.
Who pays for the ADR?
Well, that definitely depends on the situation. Oftentimes when parties are in a dispute, they have some type of contract, and in the community association arena, a lot of times that contract is the declaration, the master deed. And so I've seen provisions in which it requires that the prevailing party be reimbursed for all of its fees and costs, including those of mediation or arbitration. And I've also seen the parties agree, or in the documents, that they split the baby. And that's probably more common, is that when parties agree to do something like mediation or arbitration, that they will split the cost of the arbitrator or the mediator.